what we're going to talk about this evening, we're going to talk about a baby that's been found. We have found a baby. And Constance, I can tell you, the baby's not alive.
I know.
Go on.
Did you have a question or?
Is it your baby?
Yes, it is, yeah.
Okay. So just to clarify, you just told me the baby that we found this evening
Yeah,
is your baby.
yeah.
Right. Tell me about that, Constance. Take your time. Constance. There's no rush, Constance. I can see it's very, very distressing for you. And you're physically upset now. Alright? Please, I really want you to take your time. There is no rush. No rush whatsoever.
Yeah.
Alright? Like I said, and I promised you this yesterday, I'm not here to judge in this interview. Alright? This is your interview, and this is your opportunity to tell me what's happened.
What I have to say is going to take a little time. The defendants may remain seated throughout. On Monday, the 14th of July 2025, at the end of a lengthy trial, you were both convicted of killing your baby daughter by gross negligence manslaughter. On the 23rd of May 2024, in the first trial, another lengthy trial, you were both convicted of concealing the birth of your daughter, perverting the course of justice, and child cruelty. You must now be sentenced for all those offences. The precise details of the birth of Victoria, as you were to name your daughter, are known only to the two of you. It may well be the case that she was born in Woodcutter's Cottage, as you have both claimed. But as much of what you have said at different times cannot be relied upon, it is not possible to be exact. What is known is that the birth took place before the 5th of January 2023. On that day, the car you were driving caught fire, and when the fire had been extinguished, a placenta was found. When it was found, you had abandoned the car and made your getaway. Not only did you leave the placenta with the car, you left a vast quantity of other items, including baby clothes, a passport, personal belongings, a quantity of cash, more than 30 mobile phones, and a live cat. What then occurred over the following days was you travelled long distances using taxis, crisscrossing England between various ports. Whatever your ultimate plan, your paramount concern seems to have been to avoid detection and to get abroad, although without any passport for either of you, or indeed the baby, that may have been very difficult to achieve. In my judgment, it is clear that throughout the period from the end of December until your arrest, neither of you gave much, if any, thought to the care or welfare of your baby. Your focus was on yourselves. Martin, you gave the name of Isabella O'Brien, and Gordon the name of James Amer. No NHS antenatal care had been provided. Martin, you told hospital staff you'd travel from Leeds to avoid family. You spoke with a fake Irish accent. You claimed to be from the travelling community and had been raised in a caravan. You said you were no longer in a relationship with the father of the child, and that your family disapproved of a child being born out of wedlock. You claimed never to have been to school, not to have been registered with a GP, and didn't have an NHS number. You claimed that Gordon, using the name Amer, was a friend you'd known for about a month, but was not the father of the child. You said you didn't have anything with you for the baby. The lies told indicate the level of deception you were content to practice to suit yourselves. Another member of the public saw people matching your description with a front-facing buggy in mid-February. In terms of the date of death, having given the case issue careful consideration, in light of the limited definitive material available, I can only be satisfied so that I am sure the baby had died by the 12th of January and not a later date. After her death, you concealed her and perverted the course of justice. A high-profile and labour-intensive national search and police investigation led eventually to the discovery of your daughter's decomposed body in a supermarket bag for life, filled with rubbish and left abandoned in a shed on an allotment. When you were arrested, neither of you was prepared to give any assistance to the police about the whereabouts of your daughter's body. Your silence at that stage of events is highly significant. If, as you have both sought to claim, this was a terrible accident, why not alert the authorities then, and why, once arrested, not say where the body was to be found? You claimed you wanted dignity for your baby's body, and yet your conduct displays the complete opposite. In the course of the trials, you have both sought to put the blame on everyone else, on the police for the hunt for the baby, and you on members of the public. You've claimed some have made up what they've said or did in their presence. For others, you suggest all they wanted was their moment in the limelight. What your attitude completely fails to acknowledge is that it was the safety and well-being of your baby and the two of you that was paramount concern to the police and to members of the public. Had the police not sought to find you or to make public appeals for assistance, and members of the public not responded by reporting sightings, then many would criticise them for not acting as they should have done. Sentence. On gross negligence manslaughter, in your case, Mark Gordon, there will be an extended sentence of imprisonment amounting to 18 years, with a custodial term of 14 years and an extension period of 4 years. In my judgment, Gordon, in your case, the dangerousness test is met. I've given consideration to the provisions of Section 285 of the Sentencing Act 2020 and whether the seriousness of the offence or the offence or one or more of the other offences associated with it was such as to justify the imposition of a sentence of imprisonment for life. However, I do not find it to be. There will be the extended sentence that I've passed upon you. Martin, in your case, as the dangerousness test is not met, there will be a determinate sentence, a sentence of 14 years imprisonment. In your case, I've given consideration as to whether the custodial sentence should be of the same length as that passed in respect of Mark Gordon or not. Having reflected on the issue, I am of the view that the custodial terms should be of the same length. The issues around future risks have led me to the conclusion that Mark Gordon should be the subject of an extended sentence, and there is therefore that distinction between the two of you. On count 1, concealing the birth, the sentence in each of your cases are ones of 18 months imprisonment. Count 2, child neglect, the sentence in each of your cases, again, ones of 18 months imprisonment. On count 5, perverting the course of public justice, the sentence in each of your cases are ones of 5 years imprisonment. The sentences on counts 1, 2 and 5 are to be concurrent to each other and concurrent to the sentences on count 4. Gordon, in your case, what that means is it's likely you will serve 2/3 of that custodial term that I've imposed. If released at the end of that custodial term or at the 2/3 point, you will be on licence until the expiry of the extended period of licence in your case. Martin, in your case, you will serve 2/3 of the sentence I've imposed and then be released on licence. Released on licence, you are subject to the terms of that until the expiry of the custodial term. As the statutory surcharge clearly applies here, the appropriate orders can be drawn up. Before I leave this case, this was clearly a difficult and painstaking investigation for which many police officers were involved. I express my sincere thanks to all of those involved. Inevitably, some officers will have undertaken a significant amount of work to bring a case of this nature to court and to a conclusion, and I would particularly wish to commend Ian Valentine, Martha Bourne and Leanne Cowdery for their commitment and work on this case.